pending legal issues that have come from this case, I'd like to invite up Sarah Perry and her panel. Sarah will introduce everybody else. Sarah is a legal expert until recently housed here at the Heritage Foundation's Me Center, but is now the Vice President and Legal Counsel at Defending Education. Sarah, take it away.
Well, we have a lot of ground to cover in a very short period of time, so I'm going to get right to it. And Professor George's beautifully wrought introduction needs no elaboration, so I will issue an opening salvo to each of my panelists after I introduce them all to you. Howie Slew, to my right, is General Counsel and founder of the Jewish Coalition for Religious Liberty. He is a widely published author and the recipient of 2023's Religious Freedom Institute Religious Freedom Impact Award. Eric Baxter is Vice President and Senior Counsel at the Becket Fund for Religious Liberty, and he recently argued the Mahmood versus Taylor case that Professor George was referencing, a prior partner at Aaron Fox in DC. And Melissa Muskela is our last panelist. She's the Professor of Practice Philosophy at the University of Notre Dame, and she has spanned work in the field of ethics, political philosophy, and law, and is the author of 2016's To Whom Do Children Belong? So please welcome my panelists. Howie, we'll start with you.
Sure. So I know that this is a conference dedicated to peers, but I'm actually going to examine other ways that we could protect the rights of parents to defend their ability to raise their kids in keeping with their faith other than peers. I'm really going to focus on the First Amendment, and I'll mention a few other things very quickly at the end. As Jason mentioned at the beginning, Pierce is steeped in substantive due process, and I don't think that Pierce is the best foundation that we should lay for parental rights. I am not saying, don't hear what I'm not saying. I'm not saying that we shouldn't use it in cases. A zealous advocate, in fact, has an obligation to use it as long as it's still good law, and it is. Zealous advocates should include it, but I don't think we should make it the bedrock. Partially because of, as Jason said, there is some principled reasons. It's not clearly tied to the text of the Constitution. It runs counter some of the arguments we've been making as to how the Constitution should be, based on the text. So that's one reason. Another reason is it's not necessarily dependable. I don't think there are 5 justices on the court who are willing to extend substantive due process rights, and lower courts have actually also shown some hesitancy to do so, including in the types of cases we were talking about earlier, cases like Mahmood, or cases about confidentiality for kids who are going through transgender things in school to not tell their parents. Courts have been very hesitant to extend substantive due process, so I just don't think that it is a solid framework to build on, or solid bedrock to build on. Another reason is that it's led to bad results, right? Abortion, same-sex marriage, and those sorts of results have also been rooted in substantive due process, so we're playing with fire. What it gives us, substantive due process, it could also take away. In fact, I think it might directly hurt the case for parental rights in some instances. There was a Sixth Circuit case that was thankfully overturned by the en banc Sixth Circuit, where the court found that students had a right to an adequate education under substantive due process. And I can easily see a court saying that right to adequate education, in fact, overcomes parental rights. So it is a dangerous foundation to build on. Again, we should include it in our arguments. We should just be circumscript, and we should maybe focus more heavily on other things. I acknowledge that my First Amendment argument and the other arguments I'm going to quickly allude to really help religious parents more than secular parents. I'm sitting here as General Counsel of Jewish Coalition for Religious Liberty. That is how I think about things. Other people can think about, and I'm happy to talk about, other avenues, but that's my primary focus. If you take one thing away from what I say today, I want it to be that the First Amendment has gotten much stronger in the last few years. It's definitely possible that once upon a time, substantive due process was our strongest argument. In fact, when Pierce was argued, the First Amendment didn't even apply to the states. It only applied to the federal government, so there was no ability to bring a First Amendment argument. And in the last few decades, the First Amendment has been relatively weak, but the tide has started to turn. The First Amendment is much stronger, and I think we could put more of our emphasis on the First Amendment. I'm going to very briefly talk about, to give some context for this, Jason and I had actually written a law review article and a book about, or Jason's book, my chapter in it, about the attempts for New York to regulate the yeshivas in New York. Basically, the state had said that schools have to give substantially equivalent education to the local public schools. And the parents in the schools were worried this would prevent them from educating their kids in their faith. It was too onerous, required too much time, was too vague, gave too much power to the public schools. And in 2019, I reviewed the state of the law and concluded that the schools had a very tough road. There really weren't a lot of ways that they could succeed. They, in fact, raised a lot of procedural arguments, and the First Amendment did not look very strong in 2019. The reason it didn't look very strong is because of a case called Employment Division versus Smith, which I will talk about in a second. But I'll just say that a lower court judge in New York very quickly said that the constitutional arguments lose for the schools because of Smith. Smith was a 1990 case that dealt with two Native American counselors who were drug counselors, and they got fired for taking peyote. So bad facts make bad law. And in that case, after the counselors were fired, they were denied unemployment benefits. And they said that the reason they were smoking peyote or ingesting peyote was because they had a religious obligation, so the First Amendment should protect them. And the Supreme Court said no. People up to this point had thought that any law that burdens the free exercise of religion is subject to strict scrutiny. The state has to either grant an exemption or show that it has a really strong reason not to, and it has no alternative way of enforcing the law. In Smith, the court said no. The court said that the free exercise clause and that strict scrutiny test only applies if a law is not religiously neutral or generally applicable. And it's important for what's about to come to note those are two separate requirements. The law has to be generally applicable and religiously neutral. So in this case, Oregon's law applied to everyone. It didn't target Native Americans. It didn't target any particular religion. And the court said no free exercise clause applies. This had devastating effects immediately. Free exercise clause cases dropped 50% overnight. The cases that were brought, they almost always lost. It was a very bad time for free exercise jurisprudence. And this is what doomed cases like the New York Yeshiva cases and tons of other religious liberty cases. The seeds of things getting better actually came pretty soon after in a case called Church of Lukumi Bablu I versus Hialeah, but these were just the seeds. In that case, the court said, we can look beyond just the text of the law. It doesn't matter if the law doesn't say. That was a case about a religion called Santeria that wanted to open churches in Hialeah, and Hialeah didn't want them to, so they created a law banning killing of animals, because Santeria has animal sacrifice as part of their practice. And at first, people thought this would pass under Smith. The law just says you can't kill animals. But the Supreme Court said no. We could look past the text of the law and see, does it really target Santeria? And the court found that it did. The court found that it did for two reasons. One, because the people on the city council had made bigoted statements that were going after Santeria, and it showed that there was a secret motivation to go after Santeria. And second, because there was a religious gerrymander. Picture the maps that have legislative districts drawn in funny shapes to include some neighborhoods and exclude others. And in this case, they're going to say that map was drawn to prohibit religious conduct and allow other conduct. So even though the law appeared religiously neutral, it actually wasn't. And therefore, we can get away from Smith. Remember, if you get away from Smith, you get to strict scrutiny under the First Amendment. So the goal of religious parents and of any religious plaintiff is to get away from Smith and to the First Amendment. And Lukumi said you can get away from Smith and to the First Amendment if you can show that the law is not really religiously neutral or generally applicable. So things got, at that time, you could still win under Lukumi, but it was very hard. You had to show one of those two things, and the bar seemed to be very high. Very few religious plaintiffs won under Lukumi. Things started to get better because the court has now made much clearer how you can show a law is not religiously neutral or generally applicable. In terms of religious neutrality, the way that this was clarified was in the COVID cases. Right? In COVID cases that restricted religious exercise, the state said, oh, we're going to give some secular businesses, those that we consider essential, better treatment than churches and schools and mosques, and not every secular case, just some secular cases. And the people thought, oh, including the dissent in this case, under Lukumi, it has to be every secular case, and just the fact that there are some that are treated the same way doesn't get you out from under Smith. And in two COVID cases, Roman Catholic Diocese of Brooklyn versus Cuomo, and Newsom versus Tandon, the court said, no, if you're going to have anything that's treated better than a religious institution, it's not religiously neutral. You just have to show one secular example. So it went from having to show that every secular example was preferred to just one. So that's a major improvement. And then there's a second set of cases that culminated in Fulton, and Fulton, this deals with general applicability. So now we've already beefed up showing that a law is not religiously neutral as one way to get to the First Amendment and strict scrutiny. And another way is under Fulton. Fulton was a case where the city of Philadelphia wanted to regulate Catholic charities that were involved in foster care. And they said, oh, if you don't certify same-sex couples for foster care, you're excluded. We will no longer contract with you. And the lower court said, oh, under Smith, these anti-discrimination laws are generally applicable, no strict scrutiny. And the Supreme Court there said, oh, but the commissioners that run this, that apply these anti-discrimination laws have discretion. The laws may on their face not have any exceptions, may not say only X, Y, and Z to exclude religion, to prohibit religion and allow secular conduct, but there's discretion given to the person who enforces it. And if that exists, then the law is not generally applicable. So that created a second pathway to get past Smith under general applicability. Is there discretion in the person who enforces it? So to very quickly go back to the yeshiva cases, these two new exceptions give them new tools to fight back against attempts to regulate them. For example, there are exceptions for schools that have certain types of accreditation. There are exceptions for schools that have certain uses of language that are not given to the yeshivas. So they can make arguments they couldn't have made before Fulton and the COVID cases under the First Amendment, and their position there is better. Very, very quickly, a couple other things. In Mahmood versus Taylor, Eric talked about Yoder. And as you'll see, Yoder might be an exception to Smith that specifically deals with cases about kids in schools. And that might be a third way to get around this. It looks pretty good. The oral argument was positive, and Eric will get more into that. There are state constitutions. Just because the federal constitution has this blockade of Smith, not every state has to adopt it. So if you're in a state that has a better interpretation of its constitution, you can go through the state constitution and not the U.S. Constitution. And then there's two RFRA points. One is some states have a Religious Freedom Restoration Act. The Religious Freedom Restoration Act was meant to get around Smith, to say, oh, pretend Smith isn't there. The federal government first passed their first one. And in doing so, they said, in federal cases and state cases, but the Supreme Court for federalism reasons said, oh, this doesn't apply to the states. And now something like 36 states or so have passed their own state Religious Freedom Restoration Acts saying, pretend there's no Smith. And if you're in one of those states, you're covered. And we can talk about later potentially, or you can look, there's been a few articles written that now enough time has passed that they might be able to rewrite the federal RFRA and have it even cover the states. So there are a lot of new tools and a lot of positive ways, which I would say are probably preferable to substantive due process.
Thank you, Howie. Melissa, and then let me say I feel as though we've all been to law school very quickly with the First Amendment primer. If you would, Melissa.
Thank you. Well, I know that many have concerns that Pierce rooted parental rights in the 14th Amendment's Due Process Clause, and I agree with Howie that for religious parents, the Free Exercise Clause is probably a more effective anchor for parental rights in many instances. But of course, non-religious parents have rights also, and so we need a different anchor for those rights. And the Due Process Clause, at least for now, seems to be the most straightforward option because that's what we actually have legal precedent for. Now, I acknowledge dangers with reading unenumerated rights into the Due Process Clause, particularly dangers of judicial activism. But I think those dangers can be avoided if you follow what's sometimes referred to as the Glucksberg test, reaffirmed in Dobbs, which limits unenumerated rights to those that are deeply rooted in our nation's history and tradition, and according to some interpretations, even more strictly limits them to those that would have been recognized as such around the time of the ratification of the 14th Amendment. Now, if there's any right that passes these historical tests with flying colors, it's the right of parents to direct the education and upbringing of their children. So I want to just briefly here lay out some of that historical evidence. Reading Pierce, and of course Meyer, which Pierce relied on, in light of the relevant history, and in particular the common law tradition's understanding of parental rights, leads to the conclusion that parents do have constitutional rights to direct the education and upbringing of their children, and that those rights are both broad and strong. So parents' educational rights are broad, meaning they encompass rights of educational control well beyond the right to send a child to a private school at your own expense. And they're strong in the sense that violations of these rights merit strict scrutiny, and I think there's historical evidence for both of these things. Now, properly understanding Meyer and Pierce requires recognizing that these cases effectively declared that the liberty protected by the 14th Amendment includes parental rights as understood by the common law tradition up to that point. And according to that understanding, parental rights are based on parents' natural, pre-political obligations to maintain, protect, and educate their children. On this view, children are primarily and naturally under the jurisdiction of parents, and the state's role is subsidiary to that of parents, aimed at assisting parents without usurping their prior educational authority. In other words, the state's role is to ensure that parents are at least minimally fulfilling their duties, so no abuse or neglect, and then to help parents fulfill those duties when needed, but to do so in a way that respects the primacy of parents' authority. Common law jurist Joseph Story writes that the state is justified in interfering with, quote, the ordinary rights of parents in regard to the custody and care of their children, only in exceptional cases in which the natural presumption that the children will be properly taken care of is overridden by proof of gross misconduct. And courts in the mid-19th century, again around the time of the ratification of the 14th Amendment, frequently echoed this exact language. I should also note that although Meyer and Pierce rooted parental rights in the 14th Amendment's due process clause, the deeply rooted history and tradition of respect for parental rights at common law, as well as in statutory law and in common law-based state Supreme Court decisions of the era, could also be the basis for anchoring parents' constitutional rights in the Privileges or Immunities Clause of the 14th Amendment, or even in the 9th Amendment. One could also argue, as legal experts like Mike Ferris and David Upham are currently doing, that parental rights really are due process rights, and that given the primacy of parents' pre-political jurisdiction over their children at common law, the proper or due process for interfering with parental rights is effectively captured by the strict scrutiny standard. Interfering with parents' rights when parents are proven guilty of abuse or neglect would meet this standard. And in my view, so would enforcing things like minimal educational regulations, if needed, to ensure that children are prepared to be law-abiding, productive citizens. The writings of common law jurist James Kent, for instance, indicate that this educational minimum that the state can enforce consists in basic literacy, numeracy, and basic knowledge of the law. That standard also seems to be implicit in Pierce's discussion of the scope and limits of state educational regulations, as I'll explain in a second. So coercively enforcing anything beyond that, particularly against the objections of fit parents, would be to deprive parents of their natural jurisdiction over their children without due process of law. At any rate, whatever you think the best constitutional anchor for parents' rights is, Pierce suggests that the state's educational authority has limited scope and should be understood as subsidiary to the educational authority of parents. The text of Pierce lists 4 things that are within the scope of the state's educational regulation powers. These 4 things about which Pierce says no question is raised. Number 1, that all children of proper age attend some school, which is broadly construed to be receiving any form of education. 2, that teachers shall be of good moral character and patriotic disposition. 3, that certain studies plainly essential to good citizenship must be taught. These are all direct quotes. And 4, that nothing be taught which is manifestly inimical to the public welfare. And that's pretty strict. Certain studies plainly essential to good citizenship must be taught. That's what the state can require. And the state can forbid things manifestly inimical to the public welfare. That's a pretty high bar, in my view, for what the state can require or forbid. Any state educational action falling outside these 4 categories would therefore be one in which constitutional questions are raised. And I think this is the only way to interpret Pierce that makes sense of the opinion's claim that the act in question in the case, which required all children to attend public schools, has no reasonable relation to any purpose within the competency of the state. Unless you think that they're determining the competency of the state in this narrow way, according to these 4 things, the Act does have a clear relation to things within state interests, namely things like the assimilation of immigrants or the state deciding how it wants to educate children. So it's because, I think, requiring all students to attend public schools falls outside of these 4 narrow categories of the things that Pierce says the state can do. It's for that reason that the Act falls outside of the competency of the state and intrudes upon the prior educational authority of parents. State Supreme Court decisions based on common law also support this interpretation, and they provide even clearer evidence that parents' rights were historically understood to include the right to direct their children's education even within the public schools. From the mid-19th century to the early 20th century, there was a string of 8 cases in which parents sought to exempt their children from some aspect of the public school curriculum, things like singing classes or bookkeeping classes, pretty anodyne things. In 7 out of 8 of these cases, the parents prevailed. The state Supreme Courts in these cases argued on the basis of common law that parents by nature possess primary educational authority over their children, and that this implies a right to control their children's education even within the public schools, as long as this is not incompatible with the discipline and efficiency of the schools. In one representative case, Oklahoma parents brought a suit because their children were expelled from public school due to their refusal, at the parents' command, to participate in the singing lessons. The parents wanted their children reinstated in the schools but exempted from the singing lessons, and the Oklahoma Supreme Court decided in their favor, based precisely on the common law view that parents possess natural duties and corresponding rights to direct their children's education. And the court clarified there, and this is important, that, quote, the common law doctrine that the parent had entire control over the education of his child remains intact even after the introduction of compulsory education legislation. The court also emphatically denied that the mere act of sending a child to school is a delegation of parental authority to the school, and instead concluded that parents remain free to select the course of study of their children even within the public schools, as long as this is compatible with reasonable discipline and efficiency in the schools. Now, one last brief point that I want to make here is that looking in history and tradition also suggests that strict scrutiny is the appropriate standard of review in parental rights cases. Meyer, Pierce, and that whole string of state Supreme Court cases that I just mentioned were implicitly applying what today would be called the strict scrutiny test. Now, of course, these cases were decided prior to the development of the tiers of scrutiny doctrine, so they're not going to say this explicitly. But when you examine the reasoning, what you see is that they're effectively requiring that the laws or policies at issue be narrowly tailored to the state interest, and that they're placing the burden of proof on the state. So these basic prongs of the strict scrutiny test are present historically, and the historical indication is that based on the common law idea that parents are the prior educators of their children, the strict scrutiny standard captures that idea and protects that right.
Thank you. Yes, this is a really fascinating background and wonderful information. The Mahmood versus Taylor case, which was argued last month, April 22nd, and from which we should get a decision by the end of June, is really an example of where the rubber meets the road. You know, taking this theory, how does it actually apply in the classroom? The case, as many of you may know, arose here in Montgomery County next door when the school board in the fall of 2022 introduced new curriculum for children in pre-K through 5th grade. These were books that introduced, one of them is called Pride Puppy, a story about 2 moms who take their children to a pride parade and their puppy gets lost and they chase their puppy through the parade, and in the process they learn in alphabetical order all these different things that you might find in a pride parade, including things like drag queen and drag king, leather, lip ring, a bunch of words that are then listed at the end of the book that kids are invited to kind of search for these different things that are portrayed throughout the book. Another book about a child who a girl who identifies as a boy and goes through the process of telling her parents and her brothers and sisters and persuading them. And the message of the book from the mom is, gender doesn't have to make sense. This is just about love, that the children are the teachers, not the parents or even their public school teachers, that and teachers are told in the guidebooks to tell children doctors simply guessed at your sex when you were born and you should figure this out for yourself. And there's a whole series of books that all kind of along this line. One that I found the most shocking, actually, was one called What Are Your Words?, where this child's uncle Lior comes to visit, goes by they, them pronouns, and the child spends this whole day with the uncle trying to figure out what his or her own pronouns are. And the book goes through and says, well, it depends on how you're feeling at the moment. It's like your pronouns may change like the weather. So if you're feeling sporty and aggressive, you might use one set of pronouns. If you're tired and melancholy, you might use another set of pronouns. And this child literally is shaking in the book and anguishing about, like, what are my pronouns? And at the very end, the child and their uncle go to watch fireworks, and the child is inspired and says, oh, this is the end of the day. Says, I feel like fireworks, so I'm they, them for today, are the last sentence of the book. So to talk about how confusing is this for children to be navigating, pre-kindergarten. It even goes into Head Start, pre-kindergarten, grades 1 through 5. Not just to be figuring out like how they interact socially with other kids, how they learn, but all of a sudden questioning, am I a boy? Am I a girl? What are my pronouns? Very, very confusing things. Unsurprisingly, parents were quite upset about this in Montgomery County. The board already allowed opt-outs for anything that would impose a substantial burden on a student's or a parent's religious beliefs. And so a lot of parents started opting their children out. And the school board publicly twice announced that, yes, we will notify you before these books are read. We will allow you to opt out. The last time they said that was on March 22nd, 2023, in a public statement. The very next day, with no explanation, they issued a new statement that said, we will no longer notify you when these books are being read to your children, and we will no longer allow you to opt your child out if you find out. And that's where parents really got upset. You started having 1,000 people showing up at school board meetings in Montgomery County. Interestingly, primarily, Montgomery County has been ranked the most religiously diverse county in the nation for the last several years. Large populations of Muslim parents and Ethiopian Orthodox parents who really led this fight in saying this is outrageous, and going to school board meetings and being told by school board members that these parents were aligning themselves with xenophobes and white supremacists, that their children who testified that they didn't want to hear the books were just parroting their parents' dogma, and that parents were just looking for another reason to hate. Interestingly, all these early cases, Pierce arose at a period of high Catholic immigration. It was really pushed by the Ku Klux Klan, the legislation that led to Pierce, really pushing this idea that we have immigrants in this country. We have to make sure that they're all become uniform, that they adopt our values. Some of these early cases that Professor Muscala talked about openly say from that period, we can't have these Catholic immigrants among us. They call them the weak among us. We must kind of like raise their level in very, very bigoted statements. And you have that very same dynamic here where you have parents, largely immigrants, really some of them openly saying, like, we came here to kind of exercise a more liberal form of our religious beliefs, and now we're being told that we have to adopt this very extreme, view in the United States, and feeling that shock of this, and the school board feeling very insistent that we have to kind of make sure that every student is kind of brought to think the way we think about these issues. So, of course, Howie kind of laid out some of the different legal theories, and we had all of those theories in this case. You had statements that were clearly bigoted. The court could simply say something like, okay, you have to go back. The school board can't make those kinds of statements when it's adjudicating parents' rights. That's unconstitutional. Of course, that'd be in my view, a very poor basis to decide, then you're stuck back in a school board that says, okay, we'll adopt the same rule with nice words, right? We won't say the hurtful things. You have the odd situation where the Montgomery County law this is Maryland law, actually already requires opt-outs for any education on family life and human sexuality. So you can be a high schooler receiving the same type of instruction about gender and sexuality, and you can opt out, but if you're a kindergartner in story hour, you're forced to stay in. So the court could decide on that ground, saying there's kind of unequal treatment here, and even under Smith, that would not be a neutral and generally applicable approach. Again, not the ground I hope the court will decide on, because then you just have school boards around the country trying to do these in a more neutral and generally applicable way. So Yoder is the other ground. Yoder was a case from 1972, so over 50 years ago, where the Amish wanted to withdraw their children from public school after junior high. Wisconsin law said, no, you have to keep them in through the 10th grade. And that went to the Supreme Court, and the Supreme Court in that case said, kind of applying these principles, these Amish children are receiving sufficient education to become productive citizens and to be, functioning adults. And so, yes, we can allow the Amish to do what they've been doing for hundreds of years and educate their children through this more vo-tech type, in the community educational training. Unfortunately, since Yoder was decided in the 50 years that followed, no parents have ever won the right again to kind of opt their children out of curriculum at least at the circuit court level. And so you have 50 years of parents losing, and courts basically saying, well, Yoder was a one-off Amish ruling that doesn't really apply to other contexts, that kind of favoring, religions that are more separatist or that have more extreme beliefs from the majority, saying that we have to accommodate them, but we're not going to accommodate on these other beliefs. And so it's really a great opportunity for the court to readdress Yoder, affirm that it is part of the constitutional jurisprudence. The court in Smith said that Yoder kind of fell outside of its rule, that because it involved parental rights and religion, that you could get to the strict scrutiny analysis faster under Yoder. So it's a really important opportunity, and especially with so many cases around the country on similar issues. Montgomery County to this day is currently denying two high school seniors graduation because they opted out of the entire health curriculum and not just the sex ed portion of the health curriculum. And we have all these cases with, secret transitions, lots of issues around the country. And so this is a really important opportunity for the court to reinforce Yoder as an independent basis for the parental rights that really go back to the common law and natural law.
We are going to open it up eventually to questions, but the clock is a mortal foe of mine, and I'm watching it count down already. I'm going to pose a few questions before we open it up, and just be thinking about your questions ahead of time. When you do, identify yourself, the organization that you're with, and also no comments, just questions, please, because we want to keep things running on time. Melissa, let me start with you first of all. What are we to make of what Professor George referenced, which are the claims of Dr. Gutman? There is no a priori reason to favor one paternalistic agent over another. What do you make of that argument, and what do you believe is the strongest counter to the argument that there's no reason to really choose between the state and the parent?
Where do I start? There are a long list of a priori reasons to favor parents over the state as the paternalistic agent, and you can go with principled reasons, or you can go with empirical data about who is generally the best decision maker. You can go with reasons rooted in democratic theory about concerns of how are you going to have a government that's meant to be responsive to the will of the people if it turns out that the government itself has the power to shape the will of the next generation. That basically gets rid of democracy entirely. So it's a basic principle of limited government, basic principle of democratic government. But I think the most powerful reason is that the authority that parents have over their children is not given to it by the state. It's based on the very nature of the parent-child relationship. And this has been universally understood throughout human history, and very much understood and respected in our own legal tradition. It was well established in the English common law tradition and continued to be well established in the American common law tradition. So it really wasn't until basically progressives were worried about wanting to homogenize children, to standardize children along the lines of their preferred dominant views, that you end up with this view of, well, we need to have expert educators who are at least on a par with, if not often considered superior to, the educational authority of parents. But that's really a late stage invention. The basic principle is that parents know best, parents care most, and parents have the most alignment of interests in terms of actually wanting to promote the best interests of their children.
Howie, let me ask you a question. I know we focused on religious education and religious parents, specifically those particular protections. Let's talk a little bit about secular parents. Is the substantive due process analysis the only one to which we are relegated and must, as you said, be zealously raised, as any good attorney should do in the defensive representation of their attorney? Or, as Melissa pointed out, could we find home in the Privileges and Immunities Clause or the Ninth Amendment instead? Is that a better option for us?
So I'm definitely more sympathetic to privileges and immunities. Unfortunately, the court has basically, put it on a total back burner since cases called the slaughterhouse cases, and it really hasn't been used. Justice Thomas is a big proponent of bringing it back. There just needs to be a lot of work to be done, both in terms of convincing courts of this and in terms of really narrowing down the history and creating limiting principles so that it doesn't just turn into another due process clause. In terms of the Ninth Amendment, I'm with Judge Bork. It's an ink blot. I can't discern any meaning in it. It really has this problem of no limiting principles. I think probably the Ninth and 10th Amendments are really just fundamentally restating that federalism exists, right? James Madison was apprehensive about having a Bill of Rights because it might make people think that the government doesn't only have enumerated powers, and the Ninth and 10th Amendments could possibly be, and I'm pretty comfortable with them just being a way of showing that the federal government is in fact one of enumerated powers. And just as a higher level remark, it makes me a little uncomfortable to be looking for ways to put something into the Constitution, to say, I know that X is right, I really want X. What hook could I put it on? Gives me some discomfort in that it feels like trying to put what I want into the Constitution rather than saying what is in the Constitution.
Eric, let me talk to you a little bit about what the substantive due process analysis has looked like in terms of the collision between gender identitarianism and parental rights, because we've actually seen sort of foes and advocates of gender identitarianism raise the 14th Amendment argument within different contexts. First, as you mentioned, in school gender confidentiality policies, and there are more than 12 million public school students right now who are in districts that have express confidentiality policies. Those parents have said, we have a fundamental right to know how our child identifies at school. They've raised the due process arguments, but we have seen loss after loss after loss. Now, currently in the 11th Circuit, there's a motion for rehearing en banc in the Littlejohn versus Leon County School District case. Many of you have been following that case. Coming out of the First Circuit is Foote versus Ludlow. My understanding from counsel is that is going to the Supreme Court eventually on a cert petition as well. We can't get past the starting block on these particular cases. What do you think is hemming in the court's jurisprudential analysis on this?
I think one of the things is kind of the concerns that Howie has raised, and the lack of limits, the question, and then how do you read into the due process clause what it really means. I think one of the interesting things about Pierce is that even though it was ostensibly decided on substantive due process grounds, the court ever since has treated it as really kind of a religious case. So the first case, Barnett, that came after about the right of parents to have their kids sit out of the Pledge of Allegiance. It was brought on a religious question, even though the court didn't really directly address the religious issues in the opinion. All the concurring opinions are based on kind of religious rights under the First Amendment. Yoder, a religious case. And then most recently in the Espinoza case about the right of parents to participate in public funding that benefits kids going to private schools, the court treated all these cases as really arising under the First Amendment and the right to free exercise of religion, parents to control the religious education of their children. So part of, in our case, even though we only brought the religion claims, we do believe that once the religious right is recognized, that everybody else's right, overwhelmingly parents who have these concerns are religious, and so once you've granted all of them accommodations, there's little sense in the public schools denying other parents, but we do think that those rights should be developed. But I do think, and could be developed under different principles. But really, it's this idea, I think, that Howie already identified of like, what are the limiting principles? What is the history really? There is a very strong history that there's always been respect. Some scholars in the early founding period said things like, our scholars have identified the right as it existed at the founding period as absolute against all the world, the right of parents to control the education of their children. And so it's really a matter of kind of developing that history and figuring out how that history helps define limits under these rights.
I'm going to open it up to questions. Yes. We have a mic runner. There we go. Okay, let me start in the back with Walt, and then we can move toward the front.
Hi, Walter Weber, American Center for Law and Justice. You can tell me whether this idea is crazy, creative, or both. Why not use free speech as a foundation? Okay, wind back a second. What would stop a government from saying, before you get your driver's license, you have to undergo this session in which we are going to teach you why climate alarmism should be the biggest concern you have before you drive your gas car, right? Or why Marxism is the best form of government. It's not obvious what constitutional provision would apply to that, but it seems to me that if the right to free speech presupposes the right to free thinking, then you have to have an immunity from the government having the power to indoctrinate you. And then why wouldn't that apply just as well, if not more so, to children?
That's a great question.
Very quickly, I think the state probably could do those things. They oughtn't. It's terrible. But in a republic, the last line of defense is the people, and we should vote against someone who proposes that. But I think they probably could.
And I'll just add that there's a great article by Philip Hamburger that makes precisely this argument. And he argues that it's not so much contrary to directly to the child's right to be free from this indoctrination, but it's contrary to the parent's right, because the parent is the kind of speech agent. Education is speech. And so the state enforcing effectively parents to send their children to public schools because it's compulsory and many don't have feasible alternatives to the public schools, they're forcing parents to allow their children to be exposed to the state's preferred speech rather than to their preferred speech. And often the state's preferred speech is directly contrary to the speech messages that parents want their children to hear. So I think it's a strong argument, but I don't know if justices are any more likely to buy that than the more classical due process Pierce history tradition argument.
Other questions? Yeah, we've got two down in front. We'll take this one first.
Pierce said that parental, thanks, John Grondelski. Pierce said that parental rights could be overridden if the parents were advocating things grossly inimical to the public interest. As we see in the Mahmood case, Montgomery County was rather expansive in its idea of civil rights and the public interest being a warm and cozy environment and social consensus, et cetera. How do we constrain inflated concepts of the public interest in order to make Pierce meaningful and not nugatory?
I could say something starting on that, and I think, and particularly for this court, I think giving them a constraining principle that is clearly rooted in the history is going to be helpful here. And I would look to something like James Kent, the American common law tradition, where he says, look, the thing that the state has an interest in that's strong enough to coercively enforce is in literacy, numeracy, basic knowledge of the law. And if you look at the Pierce language, this idea of things that are plainly essential to good citizenship being required or manifestly inimical to the public welfare being forbidden, I think the plainly and the manifestly are really important. And so it seems to me there that anything that people are extremely divided on, right? Anything that, for instance, one state thinks is so bad that it should be illegal can't possibly be plainly essential to good citizenship, right? So I think those words give you also an indication that the things that the state can coercively enforce are pretty narrow.
Another question here in front.
Hi, I'm a parent and grandparent in Montgomery County, Maryland. I'm Augustus Alzona, I made sure to write this down, the patriarch of the Cornejo Alzona family of Woodley Park, Washington, D.C., and political and religious refugees from upper Northwest D.C., to Bethesda, Chevy Chase, Maryland since the early 1970s. That's it's true, but there's a little joke in there. But anyway, here's a question I have for you all. First of all, I know where all the skeletons are buried, particularly on this particular issue of parental rights. And my question, now I'm going to ask a question, do you need anybody to be a plaintiff or a witness or somebody to need to testify before whichever court you want to, local or state? And another, yeah, that's basically the question.
Well, we have a lot of attorneys and litigators in this room, so you can all collect each other after the session, and we can discover exactly who would be willing. Jason, I know, I've got the eye from Jason. We have time for one more question before we wrap up. Last question. I'm going to give you each 1 minute to close. Oh, there's Tiffany right in the back. Okay. No closing remarks from any of you. I'm sorry.
Eric, predictions on Mahmood, and I think the majority of Americans who listen to the argument believe you're going to win. The parents are going to win. What does that say for the future of parental rights in America?
Yeah, of course, you never know until the decision comes out, but it did feel really good at the oral argument. It seemed like 6 justices were clearly sympathetic to the rights. I think one other telling thing, through this litigation, the Washington Post, the New York Times, they were somewhat kind of skeptical. They had a lot of questions, but they weren't really as strongly as opposed as you might have thought on these types of issues. And if you talk to your neighbors, this is an issue that really cuts across ideological lines. There are parents on both sides of the political side who really find this instruction. And the idea that parents can't make a decision about how and when their children are taught about sexuality, they find that very offensive. After the decision, of course, Washington Post all of a sudden is like, this case is so obvious. Why did Montgomery County choose to go this far? New York Times, Wall Street Journal. So I think those all speak very well. It also speaks, though, to the fact that it took a lot of parents to actually speak up and have the courage to put their names on a lawsuit, to go through 2 years of litigation to make this happen. So even though the Washington Post can say after the fact, oh, this looks really straightforward and simple, it wasn't 2 years ago. And so I think, and going back to this question about how do we put the limits on, a lot of this has to come back to culture, that we encourage and foster religion, that we continue to talk and help people understand like what these rights entail and what their appropriate limits should be.
Yeah, and I think, interestingly, we were talking a little bit about the 2 manifestations of the 14th Amendment right. We talked about school confidentiality policies. Montgomery County already made it to the Supreme Court. Now, their petition for cert was denied, but that was the Montgomery County challenge, John and Jane Parents 1 and 2 versus Montgomery County School Districts, specifically over the unconstitutionality of these school secrecy policies. I think, in my estimation, the court's sort of historically queasy with facial challenges, and it would have liked an as-applied challenge as, maybe a more saleable concept. But, and we've got still the Scrimeti case. The parental right issue was raised. We likely won't hear anything on that issue because it will be determined on an equal protection basis. Fundamental parental rights were not argued in the oral arguments, but I think for those of us who are crossing our fingers and hoping at some point we would get some iteration on the 14th Amendment, we are unlikely to see that as well. But I am right at time. We have so much we didn't cover, but please join me in thanking our panelists.
Either. Great job. Great job. You can go on up. Awesome. Yeah. And yes, Colleen is up first. Just so you know. All right, everyone, we're going to launch right into the second panel. Can everyone hear me okay in the back? Great. There's more. There's more. You thought that was it? No. Okay. So welcome back, everybody. We're going to launch into the second panel now. That was a great conversation about the development of jurisprudence over the last 100 years. Now we want to talk about what has changed in the private sector. over the last 100 years. So the debate, Pierce v. Society of Sisters, the debate was whether the government could ban private education altogether. The debate we're having these days it's settled. You can choose a private school for your children. The debate is whether the money, the public funds, should follow the child to the parent's chosen school. And there's been a lot of changes in the private sector, in private education as well. So in those days, in the days of the Pierce decision, the public schools were essentially non-denominational Protestant schools. They taught a Protestant version of the Bible that was widely accepted. They would lead students in Protestant prayer, which is why Catholics were building their own schools. In the past century, we have seen the secularization of the public school system and the rise of all sorts of other private Protestant Christian schools, as well as Jewish schools, Muslim schools, and others. Likewise, there has been a progressive education movement. And so we have seen in the private sector the rise of classical education. And so our panelists are going to dive into these and other issues. So we will begin with Colleen Hronchek, who has my old position at the Cato Institute. Colleen is a policy analyst with the Cato Institute Center for Educational Freedom. You should check out every Friday. She has the Friday Feature blog series where she shares interesting stories in the education space, from innovative schools and exciting educational programs to inspiring students, parents, and teachers. Then we're going to hear from Derek Max, who is the president and CEO of the Thomas Jefferson Institute for Public Policy, Virginia's premier nonpartisan free market think tank. He did a short stint as a speechwriter in the United States Senate, and also spent some time at the Cato Institute. Is Cato colonizing the Heritage Foundation over here? Working on government affairs. And finally, we will hear in the middle from Stephen Noventy, who is nationally renowned for his work in education, public policy, law, organizational leadership, and governance. He currently serves as the head of school for Fort Bend Christian Academy, and he has served as vice president of public policy and general counsel for the Association of Christian Schools International. So without any further ado, Colleen.
Thank you, Jason, for, is this work?
Yep.
Okay. For inviting me here, and Heritage for hosting this. It was fun because it was back-to-back. Cato had a similar event this morning, so it's been quite a day. Jason did steal a little bit of what I was going to talk about, but I'll go a little deeper into it. And I think that as we're talking about parental rights in the 100th anniversary of Pierce, it's important to take a step back sometimes and just, school choice is a very important part of this topic, but why is there something called school choice? We don't have grocery choice, we don't have doctor choice, we don't have car dealership choice. Why do we have something called school choice? And it's, been talked about quite a bit here, but just kind of going to the roots of where this comes from. And, there's been a long history of people calling for some level of government involvement in education, going back to the ancient Greeks and maybe beyond. But there are different trains of thoughts, different motivations behind this. And in the early colonial days here in America, it was often religious. And they wanted to make sure that the children were raised up and could read and understand scriptures. The first Education Act in America was in Massachusetts. It was called, we've dubbed it the Old Deluder Satan Act, because it literally said that we need to make sure that kids can read so they can't be tricked basically by that old deluder Satan. So it's nowadays we think about this whole separation, but historically religion has been a huge part of the push for education, including state involvement in education. After the War for Independence, there was a bit of a shift. I mean, there's still always been the religious motivation, but it became more of a push on Americanizing people. John Adams and Thomas Jefferson even, they favored some level of public involvement, more on the funding side, not the government running the schools so much. And that was to have an educated citizenry. They created this new nation, and it was a republic, and it was designed, for the people to be involved and to be electing their leaders, and they wanted to make sure that the people were capable of that. Some of the founders took it a bit further. Benjamin Rush favored much more state involvement, and his motivations were much stronger, wanting a homogeneous society that was more easily governed and would be peaceable. So, there's all these different factors at play, and then we get into the 1800s and the common school movement with Horace Mann, who was a Massachusetts educator and political figure. And he really championed this idea of common schools that would bring kind of all of these pieces together. They were largely Protestant. They were designed to produce good Americans and have this common background, to have this shared background for the good of the country. And also because he had some distrust of parents and didn't want to leave kids, at the mercy of those parents who may or may not make good decisions for them. At the same time, there was a huge, as has been discussed a bit already, a huge influx of immigrants to America, and a lot of those were Irish Catholics, and there was a lot of distrust of them. And this, the idea that a few different things, the Pope, they would be loyal to the Pope, who was the foreign leader, instead of to America. And because the Catholic Church tends to be more hierarchical, that Catholics weren't going to be good citizens in a democratic republic. So there was a big nativist movement, and they kind of ran alongside each other, the common school movement and the nativist movement. And it was a lot of the fear of Catholics is what helped push the education, the compulsory education statutes and constitutional provisions over the finish line. The federal government also got involved after the Civil War, when the South wanted to rejoin the Union. There was a lot of pressure on them to put education in the constitutions. As the country was expanding westward, some of the states were mandated to include education. So there are all these forces at play that led us to this situation where we have compulsory education, compulsory schooling, let's be honest, it's not necessarily compulsory education, and it's determined by where you live. You can kind of see why in the 1800s they set it up that way. Travel was difficult, communication was difficult, so it kind of makes sense that they're like, oh, you live here, you go to this school, right? But a lot of things have changed since then, and there's been, as the country's grown more diverse, there's been growing push for more options because not everybody wants what's offered in the government school. As the religious aspects were removed from the public schools, because for the first, almost 100 years or more than 100 years in some cases, a lot of the public schools were Protestant schools. And so in the 60s, when the Supreme Court ruled against having the Bible and prayers in schools, that led to dissatisfaction among religious Christian parents who wanted those options. And then, of course, as has been mentioned, the Catholics have always had a push for some opting out, including a push for funding for a long time that has, generally wasn't successful for most of history until more recently. So that's what leads us to this school choice era, and why we have school choice, whereas we don't have all these other types of choice movements, because we don't have the compulsory nature where you're mandated to go to a specific government provider for anything else that you do. So now, in recent years, there's been a huge, of course, uptick in these school choice movements or school choice successes. And a lot of this came out of COVID, although certainly it pre-existed in the, 1990 was the first modern school voucher program in Milwaukee. And those early programs, whether it was vouchers or charter schools, they were often bipartisan. And a lot of them were, there's different angles maybe that people come at it, and for some it's more for equity because the public schools in a lot of areas, and especially in urban areas, are terrible. For some people it's more of a competition or choice, for some it's religious, but they all combine together, and we're able to have some bipartisan programs in the early era. At the Cato panel there was a little bit of discussion on why it's no longer bipartisan, and my personal opinion on that is, in large part, it's because the teachers' unions saw what was happening and didn't want that to go on anymore, and so they stepped up their political pressure on largely the Democrats who support them. And so I think that's a lot of the reason why, at the political level, it's no longer bipartisan, although it certainly is, at the parental level, very bipartisan still. So, fast forward after COVID, and we now have all sorts of types of school choice programs where, when I say school choice, I'm sure most of you in the room know this, but it's allowing some of the funding to follow kids to a variety of educational options. So we've kind of inherited this term school choice because it originally was literally, instead of going to this school that you were assigned to, you could go to this other school with this voucher. Since then, we've had tax credit scholarships and education savings accounts, which have really been transformative in terms of being able to fund a variety of different educational purchases, not just school tuition. So that's what's led to a lot of the innovative efforts that, as Jason mentioned, I write about in my Friday feature blog. And so I think we'll, in the Q&A, we'll leave something for that. But I just wanted to kind of set the stage of what we mean when we talk about educational freedom, why we even have this idea of school choice and where it came from, and then how we've jumped so far so fast in recent years to where we now have 85, I think, school choice programs on the books in 35 states plus DC and Puerto Rico. About 1.25 million kids are using school choice programs this year, and it's around 17 states now where it's almost universal eligibility. The universal term gets complicated. I won't get into all that right now, but we're getting closer to a place where, around 50% of kids soon will have some access to school choice programs in America, and to me, that's a good thing.
Oh, he's going. Yep, you're up.
First of all, I just want to thank the Heritage Foundation for hosting this event. I know Professor George has left, but it's kind of a bucket list item for me to be on a program with his name on it. So fortunately, he didn't disappoint. I've had several bucket list things where it ended up not being as great as I had expected. So anyway, I know he's gone, but this is a great day. It is indeed monumental that for 100 years since Pierce, the court has recognized what I believe to just be obvious, that parents have the right to choose how to educate their children. What is unfortunate to me, however, is that it's taken that same 100 years to recognize that having the right to choose your children's school is meaningless if you don't have the resources or the means to make that choice. As was just stated, just last year, 99 years after Pierce, we finally reached the 1 million mark of children educating their right to be educated in the school that their parents have chosen for them. I do believe with the new administration set on closing the Department of Education, yay. Really. I worked on the Hill 20 years ago, and we tried, and I think we closed one program. So anyway, but to drive those dollars back to the states, and most importantly back to parents, I believe this movement is going to continue, and it's going to make a radical difference in the lives of our children. This growth in school choice, in some sense, is unfortunate in that I think it's a reflection of a very deep and troubling crisis in public education. And I know we all banter around the idea of poor NAEP scores and poor state assessments and poor college prep exams, but really I think the crisis goes beyond testing and assessments. I believe COVID did something great for America in that it exposed the drivel that is coming out of our public schools. And parents began to open their eyes and started to ask questions. Questions like, what books are you reading? Why aren't you reading books? Just the basic things that I think ultimately have led to a movement to change the course of education. I would also just point out that our colleges, including our elite colleges, are being forced to teach remedial classes, and businesses are increasingly finding that their workforce is woefully unprepared for the tasks their workers are being given. The one-size-fits-all public education monopoly, which when you work at Cato, you got to learn that sentence, has fed our children a constant dose of new pedagogy, from whole language to new math to test-driven curricula that does little to encourage critical thought or provide the tools to self-instruct. And we have failed to create what we often talk about, the lifelong learner. And worse, over the last 10 years in particular, our schools have become an indoctrination station built around progressive ideas that are an offense to much of the public. While a robust education marketplace is likely to develop a plethora of education models, it is equally certain to weed out bad models that do not work and deserve to be closed. I am here today, I believe, because I am a firm advocate, I'm in some sense an evangelist, for an education model with roots stretching back a millennia. A model that almost died at the altar of progressive instruction, yet is now experiencing a vibrant resurgence, and I believe will be the dominant model when school choice becomes the norm. I am speaking, of course, of classical education. For too long, classical education is perceived as an antiquated approach, but as someone who founded and run a private Christian classical school here in Southeast DC, Cornerstone Schools of Washington, DC, and having visited successful classical schools around the country, my favorite of which is the Great Hearts Academies, if you've ever had the opportunity to visit them, I have seen the power of this time-tested model. Classical education isn't just about great books or Western civilization or learning Latin, which my kids hated, but more broadly is about teaching students how to learn, how to think, how to take ownership of their education and their lives. It is about ensuring that they have the tools to think logically and to engage in critical discussions centered on life's biggest questions. A classical school, again, it isn't just about the curriculum. It will have a positive discipline model that is kind, and I know Heritage sometimes hate this word, but is restorative. It will have the positive classrooms where students lead discussions and debates with respect, and teachers act as facilitators, not performers. There is no stand and deliver in a true classical school. The benefits of this approach are powerful. By grappling with complex tests and ideas, students learn to analyze and evaluate from their own judgments. This is a vital skill in navigating an increasingly complex, and I might add, increasingly dark world in which they're being raised. It builds a strong academic foundation through exposure to rich literature, history, mathematics, science interwoven with the great Latin. It cultivates intellectual curiosity and a broad base of knowledge. It engages students with timeless questions of human existence and morality, the nature of reality. Students are guided towards understanding what it means to live a good and meaningful life, and the joy of an inherent pursuit of wisdom and virtue. Classic education cultivates an appreciation of the true and beautiful, the study of art, music, poetry, literature. But often I'm asked, what about in our poorest performing schools? What about the urban African-American students? Is this form of education appropriate for them? When I ask this question, I often think back to the parents that would walk into Cornerstone and look me in the eye and say, why are my children being asked to read texts of dead white men? And I could only answer that when you looked around at the alternatives, you found education that provided vast achievement gaps, where these students had higher disciplinary instances and greater levels of dropping out. Their schools down the road from us had metal detectors and drug-sniffing dogs and the resource officers roaming the hallways. In short, there was nothing true or beautiful about the public schools with which they were exiting. I believe that our approach, the classical education approach, offered a powerful antidote to this type of education. By providing everything I've described above, these students could excel and become owners of their own education. I would tell the parents, walk down the street to the house of Frederick Douglass. Go to his library and see what he read. Or Google Martin Luther King Jr.'s home library. You would see that both of them were studied in the classics. Or I'd point them to Thomas Sowell's great article on Black excellence in the Dunbar High School experience. He noted that the classical model at Dunbar produced graduates who went on to achieve remarkable success. The first black general, the first black federal judge, the first black senator since Reconstruction, inventors like Charles Drew and writers like Sterling Brown, all graduated from a classical school named Dunbar, which was literally blocks from Cornerstone. In fact, Dunbar's first principal was the first African-American woman to graduate from college. In the year before Dunbar was segregated, 80% of its graduates went on to college, at a time when most Americans, white or black, did not. The resurgence of classical education presents an opportunity to build upon this great legacy. By having students engage with great conversations of Western thought, with their own rich intellectual traditions, helps them gain a deeper understanding of themselves and their place in this world. I often tell people to just come and sit in one of our classrooms and watch our students grapple with Plato's The Cave. And until you've studied that text in the context of a community of poverty and hear them ask themselves, are we living in a cave? Is this our cave? And then have another student say, well, do we really want to step out and find out? What if this is the best there is? It's really a powerful insight into the enduring legacy of great works that should not be restricted from any population. I guess I'll just close by saying the classical education in the United States, and again with school choice, we'll have all kinds of options. But I believe it affords a unique opportunity for African American communities to give them a beacon of hope and a just and intellectually vibrant future for their children. And I'd be remiss if in a room full like this, with a lot of young people and a lot of people who look like you have money, I would encourage you. I was your age, I was like you at one point, working on Capitol Hill when we just looked around a few blocks down the street and saw that these kids were suffering. And we said, let's just open a school. It's the hardest thing I've ever done, but the rewards, not financial, are eternal. And I would encourage you to join it. We have a race problem in this country. We have a poverty problem in this country that can be addressed not by DEI, but by providing children at a young age the ability to think critically and to perform well. And you can do it. You can open a school. You can be a part of something great. Thank you.
Thank you. And just to set the record straight, there's no problem with restorative as long as it's not paired with the term justice. That's when.
Well, I will say we use the restorative justice model as our discipline model.
Okay.
And if it's done right, it works. We can talk about that in the Q&A.
Stephen.
Well, I certainly have been involved with policy work here, both in the Capitol and different states. I was and currently still am on the ground, tip of the spear as a head of school of a K-12 Christian school in Texas. And when I think of that experience, I think of going between buildings, and there was this several years ago that comes to my memory, a little second or third grade girl, and then you're having a little cool streak of weather here in DC, but you know you're going to be in those dog days of summer. Well, in Houston, Texas, it's the dog days of summer, almost 10 months out of the year. Snow is very rare. On this particular day, it was snowing in Houston, Texas. And this little second, third grade girl, I was going between buildings, she came out on the sidewalk and she was twirling around trying to catch a snowflake on her tongue because she had never seen snow before, being a Houston native. And she said, "This is the best day of my life," full of wonder. And in her tender years, I think it probably was. And you know, at our school, we taught her just the magnificence and the marvelous and just the amazing world that we live in. You too are amazing and marvelous. You are created in the image of God. You're here for a purpose. You're special. Your life has meaning and worth. And you know, she was surrounded by teachers that loved her in partnership with parents who cared for her. And that's what's important, isn't it? If we go back to 1925, the celebration of Pierce, that was what was on the table. That's what was being considered. Do parents have the right to make sure their children are in an environment that aligns with their values? You know, 1925 was an interesting year. And we talked about the immigrant issue in America at that time, but there were bigger things at stake. In 1925, how about William Jennings Bryant, the Scopes monkey trial? Around the world in the United States, there was a clash of cultures. Whether there was in fact, the Bolshevik Revolution had just occurred. The Soviet state has just been set up, a Marxist, atheist, materialistic worldview. And here we saw it coming to America in the Scopes case. And so you had Americans saying, is this what the progressives are doing even 100 years ago in public education? And happily, the court said, no, children are not the property of the state, but parents have the superior right. That's what was happening in our world 100 years ago, and why parents were saying, we need the right to choose to opt out of some schools and the right to choose an education for our children that aligns with our responsibility as parents, that gives rise to the rights, which is part of the history and tradition of our people as Americans going back to common law. Well, fast forward, what was happening about 50 years from Pierce, you had the Yoder decision. In between, what was happening? Well, you had World War I, and then you had the Great Depression, and then you had World War II, and then all of a sudden, you saw in the 60s, back during the Pierce time, during this idea of communism and Marxism and secularism, the idea is there may be no God. Well, in the 1960s, is whether there's a God or not, there's no rules. So you had the hippie movement. You had 1968 Woodstock. You already had God kicked out of school, so to speak, in the Engel-Vidal decision in 62, and then prayer in 63, or Bible study in 63 was banned. And so now you're getting increasingly in culture, you are having a contest. So if there was no God in the Bolshevik Revolution, now in America there was no rules, especially governing the relationship between men and women. Sexual mores were out the door. What's marriage? Who needs it? And here you have an Amish community who says what's happening around us is not consistent with our values as an Amish community. And you know what? If our children go to the state school, they will lose our unique culture, our sincerely held religious beliefs. We don't want our kids. It's not so bad in elementary, but past 8th grade, we're concerned about that. If you read the case, that was the whole concern of the Amish community. And again, the court cited. In fact, the court doubled down. It quoted Vidal, but then in a First Amendment context said, and I'm quoting from the court of the Yoder court, the primary role of parents in the upbringing of their children is now established beyond debate as an enduring American tradition. Again, hearing that, the traditions of our people, even in the recent Dobbs case, you can hear that. And so you had the right to opt out in order to be consistent with one's sincerely held religious beliefs. Now 100 years later, past 1925, 2025, there may be no God. If there is a God, now we're in the middle, in the Yoder era, there's no rules between, especially sexual mores between men and women. In 2025, there may not even be men and women. In fact, there may not even be humans. Not too far from my home in Colorado, they decided to put in a litter box in the bathroom for children because they want to go under the belief that you can deny your own reality, let alone your gender. Now, what happens here? Law follows culture. Culture and law go together. Law is usually a reflection of the culture around it. So you see what happened 100 years ago, 50 years ago, and what COVID did was it pulled back the curtain of what was happening in the schools, saying now reality, basic biological reality, is being questioned. It's a fiction. It is its own religion, almost on the level of Greek mythology. You can now, or Invasion of the Body Snatchers, they put you in the wrong body. This is a hyper-religious belief contrary to not only good science, but also to any sort of, I'd say, view of reality that makes sense, and especially revealed truth as in the sacred texts and scriptures. So what have we seen as a result? You are seeing law follow culture. Parents are rightfully shocked by this and saying we need out, just like in 1925, just like in the Yoder era in the 72, and even now today. And in fact, what you've seen is public school enrollment was down 15% between the years of 2019 and 2022 as a result of COVID. People were leaving the public schools because COVID, online learning, all of a sudden parents could get into the classroom virtually, and they did see what was being given was at sometimes not only not education, it was a negative indoctrination against reality. Private school enrollment rose 22% from 2019 to 2022. We don't see those things. Homeschooling, because private school does come with a price tag, not all can afford it, homeschooling went up 144% in that 3-year period. Charter schools up 36%, school choice and micro schools also up. So since 2021, there's been a continuing legislative effort, because law follows culture, follows constituents who elect their legislators. All of a sudden, you're seeing a lot more ESA legislation, school vouchers, tax credit scholarships, and you're seeing the legislatures respond to the desire of the people to now actually give relevance to their rights as parents to once again choose where their children go. Ed Choice put out, so now and today, 2025, public school enrollment is down to only 75% of the population. Homeschool is now at 4.7%, or 1 in 20 are homeschooled. Private schools are anywhere, depending how you do the numbers, between 1 in 10 or maybe even 1 in 8. And so what we are seeing is a resurgence and a strengthening of the private school movement as a response to what we're seeing in culture around us. So what's the question? The question is, with this, with private schools, with homeschools growing, with micro schools, with the new hybrids like Great Hearts Academy, some online, the university school model, what should we be concerned about in the arena of policy and pragmatics? And I wrote down just a few comments. Number one is private schools, regardless of what form they're in, they need to be now prepared for greater swings, and it's a destabilizing force actually, greater swings in both enrollment and their own budget parameters. Why? Because what the government gives, the government can take away. And if the school is subject to scholarships flowing through parents, that all of a sudden there are administrative requirements. In a prior session, we talked about there's much mischief in administrative rulemaking. And if all of a sudden there are requirements to comply with municipal or state, let's say, anti-discrimination issues that would be contrary to biblical or Christian values in the case of Christian schools, all of a sudden they may not be able to receive tax-free scholarship monies or ESAs. And so that can swing enrollment and funding. The second thing is there has to be an increased commitment to missional integrity and fidelity to one's sincerely held religious beliefs, whether it's a Jewish school, whether it's an Islamic school, a Christian school, because as schools get larger, there's more voices. And with more voices, there's more pressure to say, do you really have to be distinctive in that area? But of course, why did they come? Because it was different from the public schools to start with. Number three is to continue and invest, all private schools, in quality teachers and quality leadership. As things get larger, it requires even more excellence. And finally, in this world of technology and artificial intelligence, well, they can be hindrances and distractions, or they can be tools. And so they are here to stay. And again, wisdom has to be, how are they used? And that's true with everything, is it not? Fire is wonderful when it's in the hearth, not so good when it's in the middle of the living room. Those are four main issues with private schools now in this post-Pierce, post-Yoder, current 2025, in this new era of parental choice with ESVs. Thank you.
All right. Well, we have plenty of time for Q&A, so I'm going to take moderator's prerogative to ask Colleen a question. Obviously, school choice has been going gangbusters since COVID, And we had 0 states in 2020 that had universal eligibility school choice. That might not be totally true universal, but where every child is eligible for publicly funded school choice. Now with the adoption of New Hampshire, hopefully soon, we'll be at 17. With the adoption of Texas this year, that brought us over the 50% mark, where now 50% of kids in K-12 education are eligible for private school choice. Is this a tipping point, or is this, we've got all the low-hanging fruit in a lot of the red states, and now it's going to start to peter out? What's the future hold for school choice?
I think a lot of what has to happen now is making sure the policies we have work well for the families, because there's a risk that as it spread so quickly and states have gone universal so quickly, which is wonderful, there's challenges with that too. Of course, when Florida went very quickly from a very targeted program to universal in the space of a few months, there were a lot of headaches that parents and schools faced in trying to get their scholarships and get the funding. And those seem to have mostly been worked out. But if that is a common pattern, then that's going to hinder future expansion. It's going to potentially hinder even the already expanded ones. So I think we're past the tipping point. Frankly, I think that I don't see parents giving up this right that they've gotten, this funding that they've gotten. I think that they will fight that and make sure that those don't go away. But I think we need to make sure that the expansions that we have are running well, make sure that they don't get bogged down in new regulations, where they've been set up with too many regulations, work to peel those back. And of course, there are still some states that, North Dakota, I think is right now considering some different school choice bills. So there are still some red states that haven't gone very far down the road yet, and so there's room to grow there. There's people looking into purple and blue state solutions, but I think that the focus for a lot of the movement needs to right now be on making sure we're doing it well where we've already gotten these passed, because if it's not working well, then that's going to be the biggest hindrance to the success of the movement and the success of the programs, and the kids and the families having good options.
Thank you. And Derek, classical education has grown tremendously, but it's still, I think, just about 1%, maybe just shy of 1% of kids in the country that are participating in it. I've spoken to a lot of families, a lot of parents who have said something along the lines of, this is what I always wanted for my children, I just didn't know it existed. So beyond school choice, which obviously presents a massive opportunity, what does the classical ed movement need to scale up?
I think success breeds success. And I think the more communities and the more parents see the uniqueness of the model, the more it'll grow. I believe 100 classical schools opened last year. At our school, we used to have parents in to sit in school. We'd close down on Monday and open on Saturday so parents could come. And it was remarkable to have low-income African-American parents walk out of, a discussion of, the Iliad or whatever, and just remark about how they wish they had been educated in that way. Seeing the students lead discussion groups and challenge each other and to debate rigorously and respectfully. I think ultimately we wouldn't have a school choice issue if education had stayed the way it was, which was more classical. But now that it's literally, the public schools are a disaster, and I don't mean to offend anybody, but I think ultimately we need to just continue to beat the horse that what is going on in these classrooms is a shame and a sham. And then from that, I think the roots of classical school can grow and take hold again.
And so, Stephen, recently the U.S. Supreme Court tied 4-4 and did not address the question of whether it would be constitutional to have religious charter schools. So setting aside the legal questions on that, just from a policy perspective, should the religious schools movement be embracing religious charters and pushing for that and seeing that as the future, or should they say, you know, that's a little too much government entanglement, we should double down on private education and try to expand private school choice options?
That's a tricky question. And I think there are two schools of thought on that. And I'll make this caveat. If one was to support the idea of religious-sponsored charter schools, to ensure that whatever implementing mechanism of funding did not end up degrading the distinctiveness, the sincerely held religious beliefs, and the missional purpose of a religious-based charter school, in whatever legislation that came in, you would need something like the religious exemption that we see in Title IX. That clearly says anything in this title that'd be contrary to an institution whose religious in nature, contrary to sincerely held religious beliefs, does not apply. You'd have to have something like that. Otherwise, you would, I think, have the danger of state influence degrading the very reason for having a religious charter school.
Well, with that, we'll open it up to the audience. Do you have any audience questions? Yes, right here.
Yes, you know, with the big, beautiful bill, thank you. With the big, beautiful bill, I hate to call it that, but that's the official name of it. And, but anyway, it passed out of the House with the provision that $5 billion would be allocated to school choice. I don't know the exact details, but one of the things in there is that it is subject to a requirement that disabilities be somehow handled. Now, from what I can tell, the adoption of disability law in the public schools under the IDEA Act have really had a very corrosive impact on school discipline, where you have misbehavior, ADHD and certain things, misbehavior under ADHD classified as a disability, and the child then is entitled to be educated in the least restrictive manner, which really means you just put them in with the other students and they have to put up with it. And if the kid is throwing chairs and beating up the other students, then tough luck. They owe it to him because he's got a privilege. Now, all that behind, the fact is that I'm kind of nervous when I see a requirement for certain disability provisions under school choice. What are your thoughts about having the government allocate funds when those funds are allocated subject to certain government requirements?
Colleen, you want to go first?
So I won't get into the issues maybe with just the federal government doing this in general, because that's a little bit outside of your question, I think, but there are issues. But just in terms of the disability component of that bill, one of the problems is a lot of what we've labeled disabilities is just by nature of we've created this school system that is against the nature of children for the most part, and we stick them in this classroom for 7 hours a day, and then when they fidget and don't want to sit in their seats, we smack them with a disability label, maybe medicate them, maybe you stick them in a special room with other kids who are having problems, and that's not good for anyone, and it's certainly not good for those children. Whereas with school choice, what happens is parents can find schools that work for their kids and work with their kids. I've talked to people and even toured micro schools that their specific outreach is for what, you know, they use the term neurodiverse children, and that could be ADHD, that can be autism, and there's all these spectrums involved, and some kids have more ability to sit still or pay attention, and others, you know, have less. But when you're in an environment that is created to work with your nature instead of in opposition to your nature, then you don't need a government, you know, IEP saying this is what we have to do, because that IEP is written because you've stuck this kid in a system that doesn't work for most kids. So just the very nature of school choice, where you let parents find an educational option that works for their kids for whatever their children's needs are, kind of gets around the very thing that they're trying to impose. So it's counterproductive, and it would be harmful for the kids, harmful for the schools, harmful for the whole notion of school choice.
I should also note, just really quick, is that this IEP mandate would be a mandate on the private schools that they have to meet certain expectations, but they're not getting additional funding that the public schools get for special needs. So it's essentially an unfunded mandate. But go ahead, Derek, you want to jump in?
Yeah, it's a dangerous topic to address. If you've done education policy, you'll know there are no more active group than parents of disabled students. So I speak carefully here. But I can say at Cornerstone, what you said is absolutely true. I would say about 90% of the IEPs that we reviewed of incoming students weren't really disabilities. A lot of them were just young men being young men, or a previous school seeking a way to get extra resources by labeling them disabled to get that. If you have a good program that can identify and teach in a constructive way, ADHD in particular can be handled. Boys need to run, they need to get their energy out, they need to explore, they need to see the world, they need to see that being a boy and being a little wild at times isn't a disability. That's just human nature. I will say though, in the harder cases are, and we've had some students like this that had, what is it, a 504 or where it's a really more severe plan that needs to be addressed. We would often take those kids as long as we could, and then when it got too severe, in DC there's a vast marketplace for schools, and there are private schools taking vouchers that are designed to handle kids like that in a much more effective way than the public schools. I would tell parents, don't take this plan to a public school, because your kid will be pushed off to the side and nobody really will care for him unless you really fight. And it's actually a tragedy what happens to a lot of these kids. But I believe markets work. Tell Cato I said that. And I believe the more students that need IEP type instruction or 504 plans, that will rise, and the good schools handling those students will be able to handle it.
I think also it goes back to being careful with the details of legislation, either at the national or state level. The idea of the word allow instead of require. I remember about 6 years ago, I was with a number of Texas members of the House and some Texas senators. We were in Arizona looking at what Arizona was doing. And I remember going to a private school that specialized in treating children with severe medical needs, esophageal, gastrointestinal issues, where they were set up to intubate nutrition and hydration through the walls of the abdomen of their students. And the private school ESAs that they had in that state allowed parents to find the schools that could actually serve those specific medical needs. Again, the legislation allowed the dollars to follow the parents to the schools that could meet the need, instead of require a school that wasn't set up to provide for those needs, whether it be a learning difference, a mental capacity issue, or whether it be a physical need. There's a difference between allow and require. And going back to Cato, free market, we believe the dollars will find a solution for the problem.
Other question? Yes.
My name is Eleftheria. Thank you. I'm from Harvard. It's interesting to say that now, given everything. But I have a question about classical education. I'm also a Greek, so I'm a big believer, some say by nature, in classical education. And I also wrote a doctorate on the subject. So I'm curious to see what your opinion is. I think it's more important than ever today because of its importance in the formation of free citizenship, essentially. And somebody mentioned AI, and the direction we've taken is very bad, I think. And I think classical education will be more important than ever in the future. Do you think that institutions of higher education in the U.S. Will go back in the direction they've taken 100 years ago, that they have abandoned a long time now, and support their students, support their faculty as they try to expand on this challenge and kind of go back to their roots? Or do you think that's kind of something that will just has been abandoned and there is no future there? One might seek new avenues in the direction you described in your comments. Thank you.
Yeah, I have a real concern about the world in which we live. The lack of character, integrity, virtue. In some sense, people would say to me with Cornerstone, only X% of your kids go on to college. And I'd say, but you know what? I'm raising young men and young women that are going to be great husbands, great wives, and great employees. Now, a lot of our students do go on to college. I had a young lady struggled. I actually just went to her graduation from Bowie State this week. It took her 6 years to get through. Graduated magna cum laude, or however you say that. I'm not even smart enough to say it. But she will tell you the classical approach and the ability to think. She said so many times she'd go into a classroom and be given a text to read, and she was like, read this 9th grade, read this 10th grade. It just gave her that ability and that confidence. But beyond the text is the drive to create virtue and a virtuous life. I think is just missing in so much of our world. Now, we were a Christian school, and we believe that it's important for kids to understand that this isn't all there is, that there's an eternity, that there's a God, that there's a design, that there's a purpose. And I believe when you marry those two things, you get students that make better choices, not just while in school, but out of school. What do you do with AI if you are just a utilitarian, just grab what you can because this world is all there is? It's a scary concept. But if you have someone that thinks broadly and deeply about their purpose and their creator and their and have answered and grappled with the big questions, I think they're going to be more prepared for a technological world with a lot of complexities. And if we don't fix this soon, I got to tell you, the cost of immorality in our world right now. In Richmond public schools, they're putting in metal detectors and bomb-sniffing dogs, and this is not helping those kids at all. It's making them feel like they're in a prison. You can't go to a 7-Eleven anymore without watching people walk out with things. It's a terrible world we're leading, and we can't continue down that road. And I do believe the classics and the classical approach has the right answer for that. So thank you for your homeland and your by nature. Anyway.
Other questions? Yes, over here. Mike is coming.
Thank you. Can you speak a little bit to the future of public education, right? One of the biggest concerns is there the capacity in private schools or charter schools to take care of all the kids, really? I went to a large public school in Orlando, 4,000 students. We had maybe 20 of those public schools in Orlando. That's a lot of kids to take care of. So I'm just interested in what you see the future of public education looking like. How can it also be helped and restored? And also, do you see a capacity to take care of really the majority of American kids? Thank you.
Well, it'll certainly look different. I don't think any of us would argue for a bunch of 4,000 student private schools to be popping up to replace those. And I don't think there's really evidence that that's the best way to go about it. Nowadays, you've got micro schools and hybrid schools and all these much more individualized entities that are reaching kids in a much different way, in a more personal way. And so, is there currently capacity for every single kid who's in public school? No, there's not. In most areas, there's not. But it will grow. You know, this is something in Florida right now. I think about I think less than half of kids go to their assigned public school in Florida now, and others go to maybe open enrollment or a magnet school or a charter school, or they're using a private school, you know, with the school choice or homeschooling through the you know, personalized education program. So that capacity grows as the funding is available, because what happened, you know, 100 plus years ago is the government took over education and it crowded out all of these other options that people were using, whether it was classical, which a lot of the schools were originally, or even, you know, Montessori was coming on board, Waldorf. So there were all these different models that were, you know, kind of up and coming, and the government schools crowded them all out. And now there's a resurgence of all of that. So there will be capacity eventually, even if not yet, but it won't look like, I don't think, our current public school system. And I think that's a good thing.
I think when Christ was asked what are the greatest commandments, he said, love the Lord your God with all your heart, your soul, your mind. And what was the second? Love your neighbor as yourself. I think that loving our neighbor means we can't give up on public institutions. I'd also say that the experiment that we've been having for the last 100 years in public education has not worked. We have now suicide as number 1 or number 2 leading cause of death among teens. Anxiety rates are through the roof. Self-harm is through the roof. And I can tell you, I can show you the Old Testament survey course and the New Testament survey course that was part of Dallas independent public school districts just about 60 years ago. And I'd ask, a value-free, Judeo-Christian, worldview-free public education, how's that worked for us? Not very well. If you go back, you can see that we are a healthier, better country back when in public education, we required the idea of a Judeo-Christian framework of ethics, teaching children they had a responsibility past their own pleasure, but they had a responsibility to their maker, to their neighbor, to their community. And I think it's a national conversation we're going to have. We don't have to be the ex-Soviet godless atheist Russia, which, by the way, the current Russia now rejects, saying that experiment failed. Do we have to go all that way that they did just to come back to where we were? And I think if we read our founders, they'll give us the answers.
Great. I think we have time for one more question.
Hi, my name is Amit, and I'm father of 4, and my wife is Catholic, South American Catholic. And when we got married, I told her if the kids were raised vegetarian, they can be baptized Catholic. So they're Christian, and I've been to church every Sunday, you know, but I'm not Catholic. So my kids first went to school in Iowa, then we moved to Utah. Then they were in a Catholic school. Then Colorado, we finally got into this charter school, and I was excited. And the problems I thought the Catholic schools had, they look very minimal compared to the charter school, because they ask them questions like, what's your sexuality? I mean, the child is 9, you know. I mean, I am not trained to answer those questions. I'm very reasonable. You know, I'm very agreeable to think if there is a logic to it. But I think you're right. This is the most dangerous set of questions that are posed in front of the kids. And kids use things to their benefit. It's human nature. So the most important thing was trust between parents. And for a while, I had to work on earn that trust back. What do you know? You know, because I gave them the independence, and they start trusting the school counselor, things like that. And they memorize these values. They were hard to get away, like, oh, I feel numb, you know. Mm-hmm. And my girl in my class is wanting to commit suicide. I mean, they just kind of learn from each other. Peer-to-peer learning in a negative way was exposed through these schools. So what is a constructive kind of set of environment where parent, teacher, and government can collaborate to kind of create a policy on a micro level that kind of, you know, we don't have to react after it has gone so far, you know.
Well, I would just say, and you addressed it, ultimately, especially this generation of kids, they desire to be heard and loved. And we teach them to love their neighbor as they love themselves. We had Muslim families at our evangelical Christian school. We had same-sex parents drop their kids off at our school. And I would explain to them, we're going to teach that Jesus is the Christ, the Son of a living God. We would say to the same-sex parents, we're going to teach that marriage between a man and a woman for a lifetime. And they chose us because their students felt loved and they felt loved. And at the end of the day, they knew what we were going to teach and where we were coming from. Now, they might have gone home and de-doctrinated them. I don't know, but I don't think you can do massive schools like the previous question for much longer. I don't think that the character and the self-restraint is going to exist to do that. I believe you have to have schools where kids can be known and loved and cared for in a way that's unique from past generations. So my hope is we'll get there and that the market will respond accordingly.
I'd be remiss if I didn't mention the Heritage Foundation's Phoenix Declaration, an American vision for education, not just private education, but also what goes on in the public schools. We cannot cede the ground. There's no such thing as a value-neutral education, and if you attempt that, you just create a vacuum that is filled by all sorts of radical ideologies. It's time that conservatives stand for traditional American values in the public school system, so we have to fight back on that front. This has been a fantastic panel, a fantastic event, I think. So round of applause for our panelists. Before everyone runs off, there are two announcements. First, right following this, there is going to be a reception. You are all invited to come join us down the hall. There'll be people guiding you. It's just out and down the hall, easy enough. And before we go, my colleague Tiffany Justice has a very exciting announcement related to parental rights that are protected in Pierce v. Society of Sisters. So, Tiffany, go ahead.
Thank you so much, Jason. Since I'm the only thing standing between you and a glass of wine, I will make this brief. There is nothing more important than protecting a parent's right to direct the upbringing of their children. But whether it's public schools pushing gender ideology or government agencies making decisions about your child's health without you, your right